What if I told you that even if your visa has expired, there are still legitimate pathways to remain in the United States legally? Before you panic, before you make any hasty decisions, stay with me for the next few minutes because I'm about to share critical information that could change your entire situation. This isn't just another immigration video. This is about real solutions for real people facing real challenges right now in 2026. Welcome back to American Visa Updates, where we break down complex immigration issues into clear, actionable information you can actually use. I'm here to help you navigate one of the most stressful situations any immigrant can face. What happens when your visa expires and you're still in the United States? If you're watching this video, chances are you or someone you know is dealing with this exact situation right now. Maybe you're lying awake at night worried about IC. Maybe you're afraid to leave your house. Maybe you're wondering if there's any way forward at all. Here's what I want you to understand right from the start. While overstaying a visa is a serious matter, it doesn't automatically mean your American dream is over. There are legal pathways, legitimate options, and real solutions available. But here's the catch. You need to know what those options are. You need to understand how they work, and you need to act strategically and carefully. Before we dive in, if this is your first time on our channel, hit that subscribe button and turn on notifications because immigration law is changing literally every single week in 2026. What was true last month might not be true today. What works in one city might not work in another. You need to stay informed, and that's exactly what we're here for. Let me start by addressing the elephant in the room. Thousands of people are reaching out asking the same questions. Jacob, I overstayed my visa. What do I do? I'm terrified. Is there any hope? Will IC come for me? Can I ever fix this? And the answer is more nuanced than a simple yes or no. The truth is that your specific situation, your individual circumstances, and the current political climate all play crucial roles in determining what options are available to you. Now, I'm going to share with you not just 3, but actually 4 legitimate pathways that people in overstay situations have successfully used to resolve their status. But before I do, I need you to understand something critical. Every single case is different. What works for your friend might not work for you. What I'm sharing here is general information to help you understand what's possible. But this absolutely does not replace personalized advice from a qualified immigration attorney who can review your specific situation. The first pathway, immediate relative petitions. Let's talk about the most common and often most powerful option available. Being sponsored by an immediate relative who is a United States citizen. This typically means either getting married to a U.S. citizen or having a parent who is a U.S. citizen petition for you. Now, you might be thinking, wait, if I overstayed my visa, isn't it too late for that? And this is where immigration law gets interesting. Under current law, immediate relatives of U.S. citizens have a special benefit that almost no other immigration category has. If you entered the United States legally, meaning you came through a port of entry with proper inspection, even if you later overstayed your visa by months or even years, you can still potentially adjust your status to permanent resident without having to leave the country first. This is huge. This is a massive protection that doesn't exist for most other visa categories. But here's where things get complicated in 2026. And this is information that many people simply aren't aware of. We're seeing significant changes in how these cases are being handled, particularly in certain geographic areas. Cities like San Diego, Phoenix, New York, and several others have seen a dramatic shift in enforcement policies. What used to be a relatively straightforward process has become considerably more challenging. Here's what's happening on the ground. Individuals who are married to U.S. citizens and who have approved immigration petitions are showing up for their adjustment of status interviews expecting to walk out with their green card or at least approval. And instead, they're being detained by immigration and customs enforcement officers right there at the USCIS office. Let that sink in for a moment. People who followed the rules, filed the paperwork, paid the fees, showed up for their interview with their U.S. citizen spouse are being taken into custody. Now, I don't want you to panic, but I do want you to be informed and prepared. The individuals who have been detained in these situations have generally been released within a few days after posting bond, and they continue fighting their cases. Many of them ultimately do get their green cards, but the process has become much more stressful, much more expensive, and requires significantly more preparation. Why is this happening? The enforcement agencies are taking a harder line, essentially saying that overstaying a visa is a violation of immigration law, regardless of whether you later married a citizen. They're using their discretionary authority to detain individuals even in cases where the law ultimately allows for adjustment of status. It's a way of making the process more difficult and discouraging people from overstaying in the first place. Third, you need to understand that despite these increased enforcement actions, this pathway is still viable and still works for thousands of people. The fundamental law hasn't changed. If you're the immediate relative of a U.S. citizen and you entered legally, you still have the legal right to adjust status despite an overstay. The enforcement actions are making it more complicated, but they're not making it impossible. I've personally worked with numerous clients in California, New York, and other states who have successfully navigated this process even in the current climate. The key is preparation, proper legal representation, and understanding exactly what you're facing. Don't just show up to an interview hoping for the best. Know what could happen, have a plan for every scenario, and make sure you're putting your best case forward. The second pathway, asylum applications. Now, let's talk about the second major pathway, applying for asylum in the United States. Asylum is a form of protection available to people who have suffered persecution or have a well-founded fear of persecution in their home country based on race, religion, nationality, membership in a particular social group, or political opinion. If you're from a country experiencing war, political turmoil, or widespread violence, or if you personally have been targeted or threatened because of who you are or what you believe, asylum might be a viable option for you, even if you've overstayed your visa. In fact, one of the unique aspects of asylum law is that your immigration status at the time you apply doesn't prevent you from being granted asylum if you're otherwise eligible. However, and this is crucial, timing matters enormously with asylum applications. Under U.S. law, you generally must apply for asylum within 1 year of your arrival in the United States. There are exceptions to this rule for changed circumstances or extraordinary circumstances, but the 1-year deadline is strictly enforced in most cases. This means if you've been in the United States for more than a year and you're just now thinking about asylum, you need to be prepared to explain why you didn't apply sooner. The asylum process in 2026 is frankly more challenging than it's been in recent years. We're seeing several concerning trends. First, there are more immigration judges who lack experience in asylum law, leading to inconsistent decision-making. Second, the evidentiary standards are getting higher, with judges expecting more documentation, more corroboration, and more detailed testimony than in the past. Third, processing times have increased significantly, with some cases taking years to resolve. Additionally, many asylum cases are being placed in administrative closure or held in abeyance, meaning they're essentially frozen without a final decision. This creates a situation where applicants have work authorization and protection from deportation, but they're living in legal limbo without knowing when or if their case will be decided. Despite these challenges, asylum remains an important and viable option for people who genuinely fear returning to their home countries. If you're from Venezuela, Nicaragua, Afghanistan, Syria, Burma, Eritrea, or many other countries experiencing serious humanitarian crisis, asylum might be your best or only option for remaining legally in the United States. There are 2 types of asylum processes you need to understand. Affirmative asylum is when you proactively file an asylum application with U.S. Citizenship and Immigration Services while you're in valid status or before your status expires. This process involves an interview with an asylum officer, and if you're denied, your case is referred to immigration court. Defensive asylum is when you're in removal proceedings, perhaps because you overstayed your visa, and you assert asylum as a defense against deportation. In defensive asylum, you present your case directly to an immigration judge. If you overstay your visa and then apply for asylum, you'll likely be in the defensive process if your application is denied initially. This means you need to be prepared for the possibility of court proceedings. However, having an asylum application pending generally protects you from deportation while your case is being decided, and you can typically obtain work authorization a few months after filing. Here's my strong recommendation. If you believe you might be eligible for asylum, Do not attempt to handle this yourself. Asylum law is one of the most complex areas of immigration law. The documentary requirements are extensive. The testimony you provide must be detailed, consistent, and credible. The legal standards are nuanced and constantly evolving. You need an experienced immigration attorney who specializes in asylum cases to evaluate your situation, help you gather the necessary evidence, and represent you effectively. I've seen too many cases where people with legitimate asylum claims were denied because they didn't present their case properly. I've also seen cases where people applied for asylum without truly qualifying, wasting years in the process and potentially creating problems for future immigration benefits. A good attorney can make the difference between success and failure in an asylum case. The third pathway, T visas for trafficking victims. Now we get to an option that most people aren't familiar with, but it's incredibly important and more common than you might think. The T visa for victims of human trafficking. When most people hear human trafficking, they think of extreme cases involving kidnapping and forced prostitution. While those situations certainly qualify, the legal definition of trafficking is actually much broader and includes many forms of labor exploitation. Human trafficking under U.S. law includes situations where someone is compelled to work through force, fraud, or coercion. This can include situations where an employer confiscates your passport, threatens to call immigration authorities if you complain, forces you to work excessive hours beyond what was promised, fails to pay agreed-upon wages, or subjects you to threats or abuse to keep you working. Let me give you a real-world example. I worked with someone who came to the United States on an H-1B visa with a software development company. This person was promised a certain salary, reasonable working hours, and professional working conditions. Within the first month, the reality was completely different. The employer took his passport, claiming they needed it for processing. They required him to work 16-hour days in what can only be described as a sweatshop environment. When he tried to complain, they threatened to terminate his visa status and report him to immigration authorities. After a month of this abuse, they fired him anyway, leaving him in an overstayed status. This is a textbook case for AT visa. The employer used his immigration status as leverage to force him into exploitative working conditions. They controlled his freedom of movement by taking his passport. They used threats and coercion to compel his labor. All of these elements constitute human trafficking under federal law. Now, your situation might not be as extreme as this example, but you might still qualify. Are you being paid less than minimum wage? Is your employer withholding wages? Did they promise you certain working conditions, but deliver something completely different? Are they using your immigration status to threaten you or prevent you from leaving? Are you working far more hours than agreed upon without proper compensation? Any of these situations could potentially qualify you for AT visa. Here's something many people don't realize. If you came to the United States on an employment-based visa like H-1B, H-2A, or H-2B, and your employer is not paying you the wages required by your visa petition, you're technically out of status. The terms of your visa require that you be paid specific wages. If that's not happening, your status is being violated through no fault of your own, but legally your acre-wing unlawful presence. This makes T visa eligibility even more important because it provides a pathway to legal status for people who were put in this position by exploitative employers. The T visa is a powerful form of relief. If approved, you receive lawful status for 4 years. You can obtain work authorization, and after 3 years, you can apply for a green card. Additionally, certain family members can be included in your application. You also don't face the same bars to reentry that you might face with other forms of overstay. To qualify for AT visa, you need to show that you're a victim of severe trafficking. You're in the United States because of that trafficking. You're complying with reasonable requests for assistance in investigating or prosecuting the trafficking unless you're under 18 or unable to cooperate due to trauma, and you would suffer extreme hardship involving unusual and severe harm if you were removed from the United States. The documentation requirements for T visas are substantial. You need to provide evidence of the trafficking, which might include employment records, communications with your employer, testimony from witnesses, police reports if applicable. and often an evaluation from a mental health professional documenting the psychological impact of the abuse. You also typically need some form of law enforcement endorsement, though there are exceptions to this requirement. The bonus fourth pathway, U visas for crime victims. I promised you 3 options, but I'm going to give you a fourth because it's incredibly relevant. The U visa for victims of crime. If you've been the victim of a qualifying criminal activity and you're cooperating with law enforcement in the investigation or prosecution of that crime, you might be eligible for a U visa even if you've overstayed your visa. Qualifying crimes include domestic violence, sexual assault, kidnapping, trafficking, extortion, blackmail, witness tampering, and many others. The full list includes dozens of different criminal activities. The key requirements are that you suffered substantial physical or mental abuse as a result of the crime, you have information about the crime, and you're willing to help law enforcement. The U visa process requires obtaining a certification from a law enforcement agency confirming that you've been helpful, are being helpful, or are likely to be helpful in investigating or prosecuting the crime. This certification, known as Form I-918-TH Supplement B, is a critical component of your application. U visas have undergone some changes recently. One significant change is that if you entered the United States without inspection, meaning you crossed the border illegally rather than being admitted at a port of entry, the U visa won't be considered a lawful admission for future immigration benefit purposes. However, if you came on a valid visa and later overstayed, the U visa can be a pathway to adjust status to permanent residence. The waiting time for U visas is currently very long, often 3 to 5 years or more from application to approval. However, applicants who are otherwise eligible can receive deferred action and work authorization while waiting for their visa number to become available. This means you have legal work authorization and protection from deportation even during the long waiting period. Critical context for all pathways. Now that I've laid out these 4 pathways, I need to give you some crucial context about the current immigration environment in 2026. Immigration enforcement has intensified significantly. Policies are changing rapidly. What was accepted practice 6 months ago might not be acceptable today. Different geographic regions are implementing enforcement differently. This means that if you're in an overstay situation, you cannot afford to delay addressing it. The longer you wait, the fewer options you may have. The longer you acre away unlawful presence, the more severe the potential consequences if you ever do have to leave the United States and try to return. It's also crucial to understand that immigration law is incredibly complex. The pathways I've described have numerous requirements, exceptions, limitations, and nuances that I simply cannot fully cover in a single video. Every case is different. Your specific country of origin, how you entered the United States, how long you've been here, what you've done while you've been here, your family relationships, your employment history, any criminal history, and dozens of other factors all influence what options are available to you and how likely they are to succeed. This is why, and I cannot stress this enough, you need to consult with a qualified immigration attorney before taking any action. Not a notario, not a document preparer, not your friend who knows someone who got a green card, but an actual licensed attorney who specializes in immigration law. Immigration law is a federal practice area that requires specialized knowledge and experience. The stakes are incredibly high. If you make a mistake, if you file the wrong application, if you disclose something incorrectly, if you miss a deadline, the consequences can be severe and long-lasting. A good immigration attorney will review your entire situation, identify all potential options, explain the risks and benefits of each pathway, help you gather the necessary documentation, prepare you for interviews or hearings, and represent your interests throughout the process. Yes, it costs money, but it's an investment in your future and your family's future. The cost of making a mistake because you tried to handle it yourself is far greater than the cost of proper legal representation. Understanding the risks. I also want to be clear about the risks you face if you're currently in overstay status. First, you're deportable. That means if you're encountered by immigration enforcement, you can be placed in removal proceedings and potentially removed from the United States. Second, you're acre-weighing unlawful presence, which can trigger bars to reentry if you leave the United States. If you accrue more than 180 days, but less than 1 year of unlawful presence, you face a 3-year bar to returning. If you accrue 1 year or more of unlawful presence, you face a 10-year bar. Third, you cannot extend or change your visa status from within the United States once you've overstayed. Fourth, if you ever apply for immigration benefits in the future, your overstay will be part of your record and can negatively impact those applications. Fifth, you're not able to work legally while in overstay status unless you have a separate work authorization, which is rare. These consequences are serious, which is why addressing your situation sooner rather than later is so important. The pathways I've described exist precisely to help people resolve their status before these consequences become permanent or insurmountable. Taking action. If you're watching this video and you're currently in overstay status, here's what you need to do. First, stop panicking. Yes, your situation is serious, but there are options available. Second, gather all your immigration documents. Your passport, your visa, your I-94 arrival departure record, any approval notices, any correspondence from immigration authorities, everything. Third, write down a detailed timeline of your immigration history. When you arrived, what status you had, when it expired, what's happened since then. Fourth, and most importantly, schedule a consultation with an immigration attorney. Many attorneys offer initial consultations at reasonable rates or sometimes even for free. Bring all your documents and your timeline to that consultation. Be completely honest about your situation. Attorney-client privilege means your attorney cannot share your information without your permission. So don't hide anything or minimize anything. The attorney needs complete information to give you accurate advice. Fifth, follow your attorney's advice. If they tell you to file an application, do it. If they tell you to gather certain documents, gather them. If they tell you not to travel, don't travel. Your attorney has the experience and knowledge to guide you through this process, but you have to trust them and follow their guidance. Staying informed. Immigration law and policy are changing constantly in 2026. New enforcement priorities are announced regularly. Court decisions create new precedents. Regulatory changes affect how applications are processed. You cannot afford to be uninformed about these changes. This is where our channel, American Visa Updates, becomes crucial for you. We monitor immigration developments daily and break them down into understandable, actionable information. We explain not just what's changing, but what it means for you and what you should do about it. We cover everything from policy announcements to court decisions to practical tips for navigating the immigration system. If you haven't already, subscribe to this channel right now and turn on all notifications. Don't miss a single video because any one of them might contain information that directly affects your case. Immigration waits for no one, and being a day late with crucial information can sometimes mean the difference between success and failure. Beyond subscribing, engage with our community. Leave comments with your questions. Share your experiences. Help others who are going through similar situations. We're all in this together, and the more we support each other with accurate information and encouragement, the better outcomes we'll all have. Final thoughts. I want to leave you with a message of hope balanced with realism. If you're in overstay status, your situation is serious and requires immediate attention, but it's not hopeless. Thousands of people successfully resolve their status every year through the pathways I've described and others. With proper legal guidance, careful preparation, and persistence, you may be able to achieve your goal of remaining in the United States legally. At the same time, I won't sugarcoat the challenges. The process will likely be stressful, expensive, and time-consuming. There are no guarantees in immigration law. Even with the best attorney and the strongest case, outcomes can be uncertain. You need to be prepared for that reality and make informed decisions about your future. What I can promise you is this: doing nothing is always the worst option. Waiting and hoping your situation will somehow resolve itself will only make things worse. Taking action, getting proper legal help, and pursuing one of the legitimate pathways available to you gives you the best chance of a positive outcome. Remember, immigration status doesn't define your worth as a person. Whatever your current situation, you deserve to be treated with dignity and respect. You deserve to have your case heard fairly. You deserve access to the legal protections and pathways that exist under U.S. law. Don't let fear or shame prevent you from seeking the help you need. That brings us to the end of today's video. I know we covered a lot of ground, and I know some of this information might feel overwhelming. That's completely normal. Immigration law is one of the most complex areas of law that exists, and navigating it while dealing with the stress of uncertain status is incredibly difficult. But here's what I want you to take away from this video. You have options. You have pathways forward, and you don't have to figure this out alone. Whether it's through immediate relative petitions, asylum, T visas, U visas, or other forms of relief we didn't even cover today, there are legitimate ways to address an overstay situation. If you found this video helpful, give it a thumbs up so more people can find this information. Share it with anyone you know who might benefit from understanding these options. And again, subscribe to American Visa Updates and hit that notification bell because we're posting new content regularly that could be crucial for your situation. If you need personalized help with your immigration case, don't hesitate to reach out to a qualified immigration attorney in your area. This video provides general information for educational purposes, but it's not legal advice and doesn't create an attorney-client relationship. Every case is unique and requires individual analysis. Thank you so much for watching. I'm passionate about helping people understand their immigration options and making complex legal information accessible to everyone who needs it. Your success is my success, and I'm rooting for every single person watching this video. Stay informed, stay hopeful, and stay proactive about your immigration situation. I'll see you in the next video where we'll tackle another crucial immigration topic. Until then, take care and remember, knowledge is power, especially in immigration matters.